I'm Aaron Parks. For many people, the word probate brings up vague but unmistakable feelings of dread, kind of like oral surgery at the dentist. Ask them what it is that creates the anxiety, though, and they generally can't tell you. The good news is that probate, particularly in Oklahoma, while it's a formal process, is not as bad as people sometimes think. This video is designed to give you a brief overview of the probate process. The first thing to know is that probate generally only applies to property that has not already been transferred at the time of someone's death. The two most common ways of transferring property are through some form of outright transfer or joint ownership, or by transfer to a legal entity, most commonly a trust. If property has been properly transferred prior to death, probate should not be needed for that property. Probate applies to most property a person owns at their death, whether they die with a will, known as dying testate, or if they die without a will, known as dying intestate. A will is a valuable legal document to have, but it does not transfer property, unlike a trust. The will must go through probate to transfer property. It's merely instructions to a court as to how property is to be transferred. That brings us to the first purpose in the probate process, the orderly transfer of property. Probate is the court-supervised process to convey property from the deceased owner to a legal heir. Before that can be done, two other purposes of probate apply. First, we need to know who the heirs are and what set of rules we're going to apply to the probate transfers. And second, we need to discharge any debts and liabilities of the deceased person. Since a simple probate in Oklahoma generally takes 4 to 6 months, probate also provides a mechanism for managing assets during that probate period. Who the heirs are and what rules apply are related questions. The first step in the probate process is setting forth a claim for who the heirs are supposed to be, whether to apply the testate or intestate statutes to the case, and who's going to manage the probate process, known as the personal representative. In a testate case, the will governs most, if not all, of the substantive aspects of what happens with property, and when and under what circumstances it is to be distributed. In an intestate probate, statutes govern the rights of surviving children, spouses, and other family members to receive estate property. However, the probate proceeding is not primarily concerned with these aspects, but is a due process issue that can mean a probate that is improperly done does not truly transfer legal ownership. A number of simple but rigid requirements accompany the steps of the probate, and at this stage in the probate typically culminates in a court order appointing the personal representative, determining whether a will exists, and determining who the heirs should be. Immediately following this step, the critically important process of eliminating or discharging debts and liabilities of the decedent occurs. This is unique to probate, and actually one of the best aspects of having to go through probate, because if the statutory process is followed correctly, at the end of 2 months, unknown claims by creditors are permanently foreclosed. In other words, probate puts the burden of learning the decedent has passed away and the responsibility of creditors to claim anything that is due them on the creditors. and after the 2-month window closes, it's too bad for the creditors. At this point, simple probates are almost ready to be distributed and closed. Again, there are time periods for undertaking this step, but if the probate is routine and the statutes are followed, this is the point at which the personal representative will ask the judge to authorize distributions of property. After the proper notices are given, the court should enter an order allowing the property to be distributed to the heirs, and after the distributions are made and proven, the estate can be closed. Probate is primarily procedural in nature, meaning that the key issue is checking the right boxes in the right order. State statutes spell out in detail exactly what the requirements are for minimum and maximum number of days, procedures for giving notice of different steps in the probate, who's to receive notice, and so forth. In a testate case, the will governs most, if not all, of the substantive aspects of what happens with property and when and under what circumstances it's to be distributed. At this point in the process, certain objections can be raised, causing the probate to become what is commonly called a contested probate. For instance, an objection could be made to the person asking to be appointed the personal representative, or an objection could be made to the validity of the will. However, the vast majority of probates are not contested. If the probate is done correctly, you can have the confidence of knowing the property went to the right people and that nobody can show up after the fact and make claims against the decedent or the property. Although probate is a bit of a hassle, these are significant benefits. However, if you're planning for your own property, you may want to consider using a trust to avoid probate and provide a structure for managing your property before and after your death without the expense and involvement of a probate court.